Welcome back to CHOWTIME Pods. Your host, Red. I got videos today from the Modern King.
Mr. Yost makes $55,000 a month. So it doesn't matter if my client needs $3,000 a month to live off of, or she needs $9,000 for extra expenses and a standard and a quality of life that she's accustomed to. That is still need.
Oh, this lawyer already rubs me the wrong way.
I'm fine with moving the discovery issues, Your Honor. We're still here. We've got 50 minutes. We can at least take even if it's the motion to modify spousal maintenance, we are more than capable of dealing with that over Zoom and handling that this afternoon, so we don't have to continually drag this out and move it to another date, which I'm sure will probably be early to mid-April. We're ready to proceed.
Sorry, man.
That's okay.
Your Honor, as the motion for spousal maintenance, that's going to involve competing experts. That is not something we're going to be able to do over Zoom, Your Honor. And that also ties in with the motion to compel and for advancement of funds, and also the denali, Your Honor. We have issues involving the domestic relations affidavit filed by Ms. Yost, and I think she's going to need to be sworn in to go over her expenses. She claims $4,000 a month every month for attorney's fees, Your Honor, amongst one.
$4 a month for what? What is she fighting? You?
Of several expenses that are questionable. So this is not something that is appropriate over Zoom.
Give me a second to review. And Angela, I misplaced my docket notes. They're buried on somewhere in here. Can you have the ability to print those out for me, please? Now, the expert witnesses, what motions were those for?
We disclosed we had an income analysis done of Mr. Yost, Your Honor. That was disclosed on January 17th through Jeff Querin. So the only part of the motion that we have dealt with that obviously is the motion to modify spousal maintenance. If the court would recall, initially when we filed this case, we're the petitioner, we had set spousal maintenance at $9,000 a month.
Damn, $9,000 a month. That's literally almost $100,000 a year. I mean, is that even 100? That is $100,000 a year. That's like 108.
And the court actually called me, this would have been through the ex parte temporary order, inquiring as to when the last year of tax returns we would have had available at that time, and that was 2018, which Mr. Yost at that time had made significantly less than what he had made over the last 3 years that we've averaged. So at the time, maintenance has been set based off of an income of Mr. Yost around $338,000, $318,000 or somewhat. And the report we've had from this income analysis that Jeff Querin has done 7 weeks ago has his income average over the last 3 years at $664,000. So again, that's not brand new news. Again, that report was issued and sent to Mr. Thompson within a couple of days, if not on January 17th. So I mean, there's been ample time to respond to that. Frankly, if we're disclosing expert reports by statute, Mr. Thompson would have had to have a responsive expert opinion within 30 days of receiving notice of us issuing that report. So that's not been done, and we're outside the 30-day window. So I really don't know what the dispute is on this motion with respect to the spousal maintenance, besides trying to continue to delay this matter. So again, we're ready to proceed. It's all argument. There's not any need besides the domestic relations affidavit, which is a sworn statement.
Man, there's just so many words getting thrown around. I hate listening to lawyer talk sometimes. It's just a lot of jargon I don't understand.
There shouldn't be any need to question anybody on the witness stand. This can be done through argument.
Your Honor, and I disagree completely. If we review Ms. Yost's domestic relations affidavit, every single expense that she listed, she deems as estimated. Every expense without a single exception. As the expert report, if I have a reply to their expert report pursuant to the rules of civil procedure, that's 30 days. I can have an independent expert, separate and apart, Your Honor. I have a demonstrative exhibit, which I anticipate. Let me try to be as succinct as I can. We cannot get this done in 45 minutes. Any one of these motions, Your Honor. Any one. The domestic relations affidavit is riddled with, well, they're all estimates. I'm entitled to inquire of Ms. Yost as to what her actual expenses are, because she has not provided a single solitary actual expense
Damn, to have everything listed as estimate? Yeah, you trying to work them.
To justify any deviation from the court's order of spousal support. None, Your Honor. Everyone's an estimate. And the court cannot make a determination based on pure estimates by the party requesting a modification of her own spousal support award.
But there's no case law to discuss that, Your Honor. Estimates are commonly used because a DRA has to be filed prior to the time of trial. Usually most pretrial conference orders require one 10 days in advance of trial or 30 days, depending on the court and jurisdiction you're in. At that point in time, it is very common practice to have the exact amounts put in. Otherwise, you put estimates in. That is something I've commonly done in 15 plus years of domestic practice. And frankly, if we're talking about my client's expenses and we want to get into the analysis on spousal maintenance, it really doesn't matter because need doesn't have to show. Of course, we're talking about need versus ability to pay. Clearly, there's an ability to pay. Before we start talking about need, it doesn't matter if my client is destitute or has to live or needs the exact amount of money she's requesting by spousal maintenance. It is need as a standard of living. Mr. Yost makes $55,000 a month. So it doesn't matter if my client needs $3,000 a month to live off of, or she needs $9,000 for extra expenses and a standard and a quality of life that she's accustomed to. That is still need. And that's what we're dealing with here. Again, there's been ample time for Mr. Thompson to respond to Dr. Querin's report from January 17th that we provided to him. We are ready to proceed. This has been set on the court's calendar for a number of weeks. We need to get moving on this immediately. There's no reason to have a half day or a day long hearing over motions to modify a temporary order. It's not that complicated.
I'm sorry. And Your Honor, I'm astounded Mr. Olson made the argument that need is not a factor. Need is most certainly a determinative factor as to spousal support.
I was going to
say.
say.
And the court cannot make a decision when every, not just one or two, every expense is estimated. And it is not for the time of trial. She is asking for a change right now. So the need right now is what we need to determine, not what she may think she needs in a year or two, which I don't even know where she's coming up with these numbers, Your Honor. Most certainly $4,000 a month in attorney's fees for every month. But, Your Honor, we're putting the cart before the horse.
First, equal rights means you support yourself after divorce. It doesn't matter if he makes $5,000 or $500,000 a month. He shouldn't be required to take care of another grown, fully capable adult. Next, how does she not know how much her expenses are? We all know why she has to resort to a wide estimate, and it's because she doesn't know how much she wants to spend at the mall this month. She doesn't need that money to survive.
True.
She just wants to live lavish lifestyle off of her ex-husband.
May I at least inquire? My clients are, a bit of a hard spot financially, which is ridiculous considering the assets that these parties have available to them. One of the things that we've requested in our motion, one of them was that under the temporary order, there was a savings account through Credit Union of America, I believe, that had about $318,000 in it. And part of our temporary order had that account being split. Can we at least either address that, or the court would grant my client some advancement on property settlement, even if it's $20,000 or something like that, since we're going to be pushing this out till the end of April. I know I'm not trying to down.
So you left him, and now you're a broke, dusty, musty, crusty, and you're asking for his assets.
$20,000 is a lot of money. It is not a lot of money for the assets involved in this case, and Mr. Yost is in control of all of them. So if there's some just temporary relief that my client can have, and again, I say that in the sense of advancement on property settlement, because if the court orders for her to be awarded an advancement on property settlement of $20,000, it's not that money just goes away and is forgotten. That would be a line item on a marital estate spreadsheet that she's already received that money, prior to the court's final disposition or whatever agreement can be reached if ever it comes to that. So again, with this being April 30th now, before we're going to be able to bring this up again, we would ask for at least some temporary relief that is not an amount of money that there's not cash available to do that. It makes no sense to me that that would be something that would be contested, I guess, because of the financial resources available to the parties.
She's in a financial hard spot because you apparently charge her $4,000 a month in attorney's fees. But that's not the only reason. She also refuses to support herself at all and would rather go after her ex-husband's assets so she can continue living off of him, how she did before she divorced him. They keep misusing the word need. She gets over 6 figures in spousal support. You do not need over 6 figures a year in spousal support. Most working adults don't even make half of that, and they're
True.
actually
Well, it's the average for like 47.
working hard rather than trying to leech off of an ex-partner. But because he made the mistake of marrying her, he's now legally on the hook for half of his assets, even though she didn't financially contribute to those assets. This is why men are simply choosing to avoid marriage altogether and will continue to do so unless the laws change.
You know, this is exactly why MGTOW is a thing. This is exactly why I wouldn't really, push you guys to getting married unless you guys want it yourselves. Because this is going to be part of it. Yeah, I'm not saying that all marriages are going to end like this, but a good amount of marriages will be similar to this, right? And even if we vetted the person properly and things like that, there's always a chance of these things happening. And some men, they don't want to take that risk, period. And I'm perfectly okay with that. Please like, subscribe, comment down below. I really appreciate that. And I'll catch you guys next time. Ciao.